My mother-in-law Diana sat in her new beach condo, the one she bought with my son's college fund, when the lawyer knocked. I watched from my car across the street as she opened the door, confident smile already forming. The lawyer was a woman in her 50s, carrying a leather portfolio. Diana invited her in. Through the window, I could see Diana's posture, relaxed, entitled, exactly how she'd been at my kitchen table 3 weeks ago when she told me children don't understand money. The lawyer opened her portfolio. Diana leaned forward to look. Then I saw it. Her hands started shaking. The papers fell from her fingers onto her new white carpet, the one she bought with money that was supposed to send my son to college. Let me tell you how we got here. My husband Michael died on October 3rd, 2022. 41 years old, heart attack at his desk. We'd been married for 12 years. Our son James was 8. Michael had been meticulous about planning. He worked in financial services at Morgan Stanley, and he'd set up everything. The college fund was his masterpiece. He'd started it the day James was born, contributing $500 monthly, making additional deposits from bonuses. By the time Michael died, that account held $95,000. It was designated specifically for James's education, with documentation Michael had prepared himself. He'd made me the sole trustee and beneficiary administrator. Everything was legal. Everything was protected. Or so I thought. Diana had never approved of me. From the moment Michael introduced us in 2009, she made it clear I wasn't good enough for her son. I was a kindergarten teacher making $43,000 a year. Michael was already earning $120,000 at 28. She's very sweet, Diana told Michael at that first dinner, the word sweet delivered like an insult. She smiled at me. Do you have any ambitions beyond teaching? Over the years, the comments accumulated. At our wedding in 2010, I hope you signed a prenuptial agreement, Michael. When I got pregnant in 2013, well, at least she'll have something to do now besides grade coloring pages. When we bought our first house in 2015, Michael's money certainly opens doors, doesn't it? I smiled through all of it. Michael would squeeze my hand under the table, and I'd let it go. But Diana had one skill I never anticipated. She was a master at legal maneuvering. Her late husband had been an estate attorney, and she'd absorbed enough knowledge to be dangerous. After Michael died, she inserted herself into everything. She showed up at the lawyer's office when I met with the estate attorney. She appeared at the bank when I went to handle Michael's accounts. I'm just trying to help, she'd say, touching my shoulder with her manicured hand. You've never dealt with this kind of money before. She was right about that. Michael's life insurance paid out $750,000. His 401k had another $340,000. The house was paid off, worth about $520,000. Suddenly, I was managing assets worth over $1.6 million, and I had no idea what I was doing. I was 33 years old, a widow with an 8-year-old son, and every financial decision felt paralyzing. Diana volunteered to help. She knew estate attorneys. She understood investment strategies. She'd managed her own finances for 15 years since her husband died. Let me guide you, she said at Michael's funeral reception, while I was still numb. Michael would want his mother to make sure his family is taken care of. For 18 months, I let her. She sat with me during meetings with financial advisors. She reviewed the statements from Michael's accounts. She asked questions I didn't know to ask. And slowly, carefully, she gathered information. Account numbers. Password reset questions. Security details. I didn't see it happening. I was grieving. I was overwhelmed. I was trying to keep James's life stable while processing my own loss. But there was one thing I did right, even in the fog of grief. I kept the college fund completely separate. Michael had been explicit about it. That account is for James's education only, he'd written in the trust documentation. No withdrawals except for qualified educational expenses. No exceptions. The account was held at a different bank than our other assets, Fidelity, not Chase. I never mentioned it in Diana's presence. Something in my gut told me to keep that one thing private. Then came March 15, 2024. Diana called me at 11:32 a.m. on a Thursday. I need to talk to you about James's future, she said. Her voice had that tone, the one that always preceded her explaining why my ideas were inadequate. Can I come by this afternoon? She arrived at 2 p.m. exactly, carrying a folder. We sat at my kitchen table, the same table where Michael and I used to review our finances every Sunday morning. Diana opened her folder and pulled out printed spreadsheets. I've been analyzing your financial situation, she said. And I'm concerned. I listened as she explained. My teaching salary, now $47,500, wasn't enough. The life insurance money was invested, but markets were volatile. The house needed maintenance I couldn't afford. James would need private school, tutoring, college preparation courses. You're not thinking long-term, Diana said. Then she got to the point. I know about the college fund, she said. Michael told me about it before he died. $95,000 just sitting there. James is 10 years old. He doesn't need that money for 8 more years. But you need money now. I felt something shift in my chest. That account is designated for his education, I said. Michael was very specific. Michael's dead. Diana's voice was flat. You're the one dealing with reality now. And the reality is that money is wasted in an account for a child who doesn't understand what it means. You should withdraw it, invest it in something sensible. I can help you manage it properly. No, I said. Diana smiled. The smile that meant she was about to explain why I was wrong. Sweetheart, you're not qualified to make this decision. You've never managed this kind of money. Michael would want me to guide you. I'm his mother. I have his interests and James's interests at heart. The answer is no, I said again. She stood up, gathered her folder. You're being emotional instead of practical. Think about it. I'll call you in a few days when you've had time to consider. I didn't think about it. I thought I'd won. I thought saying no was enough. I was wrong. On April 2nd, 2024, I got an alert on my phone. The Fidelity account had been accessed from a new device. I logged in immediately. The balance showed $127.43. The $95,000 was gone. Withdrawn on April 1st at 3:47 p.m. Transferred to an external account I didn't recognize. My hands shook so hard I dropped my phone. I called Fidelity. They confirmed the withdrawal was processed with proper authorization, account number, password, security questions all answered correctly. But I didn't authorize this, I said. The representative was sympathetic but clear. The withdrawal was legal. Someone with access to my account information had initiated it. I knew exactly who. I called Diana. She answered on the first ring. Did you take James's college fund? My voice sounded strange, too high, too tight. I made a decision that needed to be made, Diana said calmly. I'm his grandmother. That money will be used for his benefit, just more wisely than leaving it dormant. I've purchased an investment property, a beach condo in Destin, Florida. It's already appreciated $8,000 in value. In 8 years, when James needs college money, we can sell it for a significant profit. You'll thank me. You stole from your grandson. I invested for my grandson. You weren't capable of making the right choice, so I made it for you. The property is in my name, but it's for James's future. You're too emotional to see that now, but eventually you'll understand this was the right decision. She hung up. I sat at my kitchen table for 6 minutes, not moving. James was at school. The house was silent except for the refrigerator humming. I'd been underestimated my entire marriage. I'd been dismissed, condescended to, treated like an incompetent child. But this was different. This wasn't about me. This was about my son's future, the future his father had meticulously planned and protected. I picked up my phone and made a call. Not to a lawyer yet. To someone Diana didn't know existed. Someone I'd been talking to for 3 months. After Michael died, I'd done something Diana never knew about. I'd taken an online course in estate law and financial planning through Columbia University's continuing education program. It cost me $2,400. I'd finished it in January 2024. The instructor, Professor Rebecca Marsh, had mentioned during one lecture that she also consulted privately on estate disputes. I'd reached out to her in February after Diana's first aggressive push to access Michael's accounts. Mrs. Torres, Professor Marsh answered. I've been expecting your call. I'd already sent her copies of all the trust documentation Michael had created. She'd reviewed everything. And she told me something that changed everything. If anyone accesses that college fund without proper legal authority, they're not just violating a trust agreement. Given that your husband specified it as an educational trust for a minor, and given that you're the designated trustee, unauthorized access constitutes both civil and criminal theft. But more importantly, your husband was very smart. Look at Section 7, subsection C of the trust document. I'd read it a dozen times since that conversation. Michael had included a clause that if anyone other than me attempted to access or redirect the funds, the entire trust would be triggered into a different legal structure, one that automatically initiated legal proceedings and froze any transferred assets pending court review. It was insurance against exactly what Diana had just done. She took the money this morning, I told Professor Marsh. Transferred it and bought property with it. Then we proceed exactly as we discussed, Professor Marsh said. I'm filing the paperwork within the hour. The Florida property will be frozen by tomorrow morning. And Mrs. Torres? Given what your mother-in-law just did, I think we should pursue the criminal complaint as well, not just the civil recovery. Do it, I said. For the next 2 weeks, I didn't contact Diana. I let her think she'd won. Let her enjoy her beach condo, the one with the white carpet and the ocean view, the one she bought with my son's future. Professor Marsh worked behind the scenes. Legal documents were filed in both New York and Florida. A forensic accountant traced the exact movement of funds from the Fidelity account to Diana's bank account to the real estate transaction. On April 16th, Professor Marsh called me. Everything's ready. The Florida court has issued a freeze order on the property. The New York court has scheduled an emergency hearing for the trust violation. And I've sent someone to serve your mother-in-law with the legal notification. She should be receiving it right about now. I drove to Destin, 6 hours from our home in Atlanta. I parked across the street from Diana's new condo at 3:30 p.m. At 3:45 p.m., a woman in a charcoal suit walked up to Diana's door carrying a leather portfolio. Attorney Sarah Chin, the Florida lawyer Professor Marsh had retained. I watched Diana answer the door, watched her invite Attorney Chen inside with that confident smile. Through the window, I saw Diana gesture at her condo, probably explaining her brilliant investment strategy. Attorney Chen opened her portfolio and handed Diana the documents. I watched Diana's face as she read. Watched her lean forward. Watched her hands start to shake. The papers slipped from her fingers onto that pristine white carpet. I got out of my car and walked to the door. It was still open. Diana stood frozen in her living room, Attorney Chen beside her. Diana looked up when I walked in. The color had drained from her face. The account was protected by a legal trust your son created, Attorney Chen was saying. The withdrawal you made triggered an automatic legal response. The court has frozen this property pending resolution of the theft complaint. Additionally, criminal charges are being considered for theft from a minor's designated trust fund. The total value of the claim, including the original $95,000, the property purchase, and punitive damages, is currently $240,000. Diana's eyes met mine. You can't do this. I'm James's grandmother. I was trying to help. You stole from him, I said. My voice was steady, calm. I'd practiced this moment for 2 weeks. You accessed an account you had no legal authority to touch. You took money designated for a minor's education. You committed fraud to do it. You used my personal information without permission. And you did it because you thought I was too stupid to stop you. I'll return the money, Diana said. Her voice cracked. I'll sell the condo. This is a misunderstanding. Attorney Chen pulled out another document. The property is already frozen by court order. You can't sell it. And the trust documentation your son created includes a clause that any attempted theft triggers not just return of funds, but punitive damages. Mrs. Torres isn't asking for the money back. She's asking for full legal accountability. Diana turned to me. Please. I'm Michael's mother. Your son's grandmother. You can't destroy me over this. You destroyed yourself, I said. Michael protected that account specifically because he knew someone might try exactly what you did. He knew his family. He knew you. He made me the trustee because he trusted me to protect our son's future. You gambled that I was too incompetent to understand what he'd done. You lost." Diana's hands were still shaking. She looked down at them like they belonged to someone else. "What do you want?" "I want you to stand in court and explain to a judge why you stole $95,000 from your 10-year-old grandson," I said. "I want the condo sold and every penny returned, plus damages. I want a legal order preventing you from ever accessing any account associated with James. And I want you to understand that underestimating someone doesn't make them weak. It makes you blind." The court hearing was scheduled for May 8, 2024. Diana showed up with her own attorney, a man in his 60s who looked tired before the proceedings even began. I sat with Professor Marsh and Attorney Chen. James was at school, unaware of any of this. That's how I wanted it. This was between adults. The judge was a woman in her early 50s named Judge Patricia Brennan. She'd reviewed all the documentation before the hearing. Diana's attorney tried to argue that this was a family misunderstanding, that Diana had intended to invest the money wisely for her grandson's benefit, that criminal charges were excessive. Judge Brennan cut him off. "Counsel, your client accessed a legally protected trust fund without authorization, used fraudulently obtained information to do so, transferred $95,000 to her personal account, and used it to purchase property in her own name. The documentation clearly designates Mrs. Lauren Torres as the sole trustee with exclusive authority over the account. What part of this do you consider a misunderstanding?" Diana's attorney shifted. "Your Honor, Mrs. Diana Torres is the grandmother. She believed she was acting in the child's best interest. What she believed is irrelevant to what she did," Judge Brennan said. She looked at Diana directly. "Mrs. Torres, did you have written authorization from the account trustee to access this fund?" "No, but..." "Did you inform Mrs. Lauren Torres before making the withdrawal?" She wouldn't have understood. "That's not what I asked." "Did you inform her?" "No." "Did you use her personal information, account numbers, passwords, security questions, without her knowledge or permission?" Diana's voice was barely audible. "Yes." Judge Brennan looked down at the trust document, the one Michael had created 6 years earlier. "Your son was very thorough. This trust specifically protects against unauthorized access. It designates educational use only. It names his wife as the sole person with authority to make decisions about the fund. You violated every protection he put in place." "Why?" Diana didn't answer immediately. When she did, her voice was different. Smaller. "I thought I knew better. I thought she couldn't manage it properly." "You thought wrong," Judge Brennan said. "The court finds that Mrs. Diana Torres committed unauthorized access and theft of funds from a protected minor's trust. The Florida property will be sold immediately. All proceeds will be returned to the trust account, managed exclusively by Mrs. Lauren Torres as trustee. Additionally, Mrs. Diana Torres will pay $45,000 in punitive damages to compensate for legal fees, lost investment opportunity, and breach of trust. A permanent restraining order will prevent Mrs. Diana Torres from accessing or attempting to access any financial accounts associated with the minor, James Torres. This order is effective immediately and permanent." Diana's attorney tried to speak. Judge Brennan held up her hand. "I'm not finished. Mrs. Diana Torres, you had every advantage in this situation. You had knowledge of estate law. You had access to resources. You had time to consider your actions. And you chose to steal from your own grandson because you believed his mother was too incompetent to stop you. That assumption has cost you $140,000, a property you can't keep, and any legal access to your grandson's financial future. Do you understand the court's order?" "Yes," Diana whispered. "Then we're done here." I walked out of the courthouse at 2:47 p.m. The Atlanta sun was bright. I'd taken the day off from teaching. James was with my sister, playing at the park, completely unaware that his college fund had just been secured permanently. Professor Marsh walked out beside me. "The property will be listed for sale next week. Given the current market, we should have the funds transferred back within 60 days. With the punitive damages, the total should be around $148,000 once everything settles." Thank you, I said. You know what impressed me most? Professor Marsh said. You waited. You didn't call her screaming. You didn't post about it on social media. You didn't try to handle it yourself. You called someone who knew what they were doing, and you let the law work exactly how it's supposed to. That takes remarkable control. My husband taught me something, I said. He used to say that the people who underestimate you are giving you an advantage. They're showing you exactly what they think your limits are. And then you get to show them they were wrong. The condo sold on June 23rd for $103,000. With the original $95,000 theft, Diana's account had held $103,000 from the sale. After the court-ordered return and damages, the total transferred back to James's college fund was $148,000. I immediately moved it to a new Fidelity account with additional security measures and a new trustee designation that specifically excluded Diana from any knowledge of or access to the account. Diana tried to call me 3 times in July. I didn't answer. She sent a letter in August, explaining that she'd only wanted to help, that she'd made a mistake, that she hoped we could reconcile for James's sake. I filed the letter with the legal documentation and didn't respond. In September, I got an email from Diana's neighbor in her primary residence. Diana had listed her house for sale. The for sale sign went up on September 10th. The house sold in October for $340,000. Diana moved to a rental apartment in a less expensive area. I heard through Michael's cousin that she'd had to liquidate some of her own investments to cover the legal judgment and damages. Her financial position had shifted significantly. The woman who'd lectured me about managing money had lost roughly $180,000 through her own actions. James started 5th grade in September 2024. He didn't know any of this had happened. He knew his grandmother wasn't visiting as much, but I explained it simply. Grandma Diana and I had a disagreement about grown-up things. Sometimes adults need space from each other. He accepted it and went back to his homework. I continued teaching. My salary increased to $51,200 with the new academic year. I finished a second course through Columbia in Educational Trust Management. I hired my own financial advisor, someone Professor Marsh recommended, to manage the life insurance investments. I learned to read investment statements. I learned to ask questions. I learned that being underestimated isn't a weakness, it's information. By December 2024, everything had settled into a new pattern. The college fund was secure, now holding $151,000 with the additional interest and investment growth. The house was maintained. James was thriving at school. Diana existed somewhere in the background of our lives, distant and diminished. I'd won completely. The court had validated every action I'd taken. My son's future was protected. Life was stable. For 3 months, everything was quiet. Too quiet, maybe? I should have known Diana better than that. Then last week, my financial advisor called. Lauren, I need you to look at something. Diana Torres just filed a lawsuit claiming that the original trust document was created under undue influence from your late husband, and that as Michael's mother, she has legal grounds to contest the trust structure itself. She's claiming the entire thing should be invalidated and the funds redistributed according to standard inheritance law, which would give her partial claim to James's assets as a direct blood relative. I sat down at my kitchen table, the same table where this all started. I opened my safe and pulled out the file Professor Marsh had prepared last year. Inside was a video recording dated March 8, 2024, 8 days before Diana first approached me about the college fund. In the recording, Diana spoke to someone on the phone, someone I'd hired to pose as an estate attorney. In that conversation, Diana explicitly outlined her plan to access the college fund, acknowledged it was legally protected, and discussed ways to circumvent my authority as trustee. I'd been waiting for her to try something like this. I'd known someone that entitled wouldn't stop after one defeat. They'd look for another angle, another strategy, another way to prove they were smarter than everyone else. I texted my attorney, she filed. I have the recording. When do you need it? The response came back immediately. Send it now. This will be over in 48 hours. I attached the video file and pressed send. Then I made myself tea and waited. Diana thought she'd found a new way in. She thought I wouldn't have anticipated this. She thought I was still the overwhelmed widow who didn't understand legal strategy. She was about to learn exactly how wrong she was. So what do you think? Did Diana go too far, or was I justified? Let me know in the comments and subscribe for more family justice stories.